rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We are here today at the time set for oral argument on Thompson Thrift Development, Inc. v. Leland C. Albertson, Jr. et al. Our case number 1, CA-CV23-0082. Counsel, each of you have 20 minutes. Counsel for the appellant, if you want to reserve time for rebuttal, it's up to you to keep track and do it yourself. We have conferenced this matter this morning. We have reviewed the briefs, read the briefs, and reviewed the records, so we're relatively familiar with the facts. Please keep that in mind when making your argument. We will be recording and live streaming this on YouTube, so when you get up and introduce yourself, please state your name and who you represent so everyone can keep track. I think that's everything I need to cover, so we'll begin with appellant.
Good morning, Your Honors. May it please the Court, my name is Chaz Workin. I represent the appellants. At bottom, this is a case about the protection of property rights, particularly the right to live in a residential-only neighborhood. And this case is determined by Callaway. The holding of Callaway was that amendments to restrictions could only be made if the declaration gave objectively fair or sufficient notice that the prospective or proposed amendment might be adopted in the future. In other words, the amendment has to be foreseeable. It also has to be reasonable.
Mr. Workin, since we're going to dive right into notice, let's start with the proposition that in Callaway, a lot of the things that the owners, the non-objecting owners, had put in there weren't anywhere in the original CC&Rs. You agree with that characterization?
I think that's a fair characterization, okay. Yes.
By contrast here, isn't the provision about the covenant of residential restriction, wasn't that in the original declaration and then was taken out?
It was in the original declaration. It is still in the declaration. What we have here is a situation where 3 of the lots have been removed from the restrictions.
Correct. But that is the covenant that we're talking about here.
Yes, we're talking about the residential-only restriction, and there are a couple of other incidental restrictions that go along with that.
And that in original declaration also includes a modification provision of a means of amending.
It does.
Okay.
It does.
So taken together with the amendment and the covenant or the restriction that was amended, isn't that notice under Callaway?
No, it is not. It is not notice. No one could have foreseen that residential-only restriction would ever be changed to allow commercial development of any of these lots.
How can you
that
say
is
that?
Beyond imagination.
Because as I read the CC&Rs, it says every 10 years, anytime 51% of the members decide we don't like these restrictions anymore, we can just do away with them all. They can all turn to commercial.
That any amendment still...
But, I mean, it's not one of those in perpetuity. It says
yes.
You have to get affirmative votes of 51% every 10 years, or this becomes commercial.
Well, actually, Your Honor, I think it automatically renews every 10 years. A change would require an affirmative action.
But it's not an automatic. It says in the CC&Rs it's up for vote every 10 years.
It says that they renew every 10. There's a duration clause.
It says renewed every 10 unless voted down. Okay.
Yeah, but I think that's here nor right. There. But
so how could you not be on notice that anytime 51 of my neighbors, assuming there's 100 lots, 51% of my neighbors want to turn this commercial, we're going commercial.
That it only gives you notice that the restrictions can be changed, and the general power of amendment. It gives
you notice that the entire thing can go out the window.
But that isn't what happened here. But,
right.
Okay. But under Callaway, as Callaway acknowledges, the general power of amendment is not a power to adopt restrictions that are not foreseeable and reasonable. And so, I don't care if 51% of 100 people decide that they want to, turn this subdivision into an amusement park. That can't be done. It's not foreseeable.
But you agree with me, if this was the 10-year renewal and 51% had said, we're not renewing, and voted no, we've got an amusement park. And there's nothing your client could argue about.
No, I disagree.
How?
Because the restrictions, there's a vested property right here to live in a residential-only neighborhood.
No, but you didn't enter into a CC&Rs that say this is going to be residential only forever. It says residential only for 10 years renewal.
Okay. But,
Right?
But
Tell me, I'm not trying to berate or beat, but I just don't understand
Is
what I'm
there some
missing.
sort of set-aside that residential gets a preferred status in a CC&R over something else about the size of your garage? I mean, it feels like that's what you're saying, is that they chose residential originally, and that just can't be changed. It just can't, because they wanted to live in a residential neighborhood.
correct.
So it gets some sort of preferred status over anything else in the CC&Rs as to how their property can be used?
Well, the changes have to be foreseeable and reasonable.
But isn't just the fact that you're choosing one thing or another, there's always going to be another option? And, I mean, Callaway says, look, if you knew that there were options chosen and the property owners want to change from one option to another, that's fine. You can't come up with wholly new options that you are going to give restrictions on. But if you've chosen options, we've chosen residential, not commercial, then that's up for grabs if you want to make a different choice. And that's what notice is that you gave the homeowners notice that you've made selections, and those selections may change.
Okay, but what happened here is not a case of a majority of the owners deciding to change the restrictions uniformly.
Well, that's a different part of your argument, is that
It's a very important part because it's part of the common law and it's one of the vested rights of each of the owners, and it's recognized by several cases in
don't your
this state.
CC&Rs say that only some of the lots may be affected by changes?
No, the CC&Rs do not say that. The CC&Rs say, the restrictions say that these restrictions can be amended.
It says in whole or part.
To apply to fewer than all of the lots or less than all of the property that is bound by the declaration.
But still, it has to be, the specific amendment has to be foreseeable.
Right, but when we were asking you about foreseeable, then you shifted over to, well, but this didn't happen because only a few lots got pulled out. And then we say, well, it allows for a few lots. And then you say, yeah, but then I'm going to go back to whether it's foreseeable.
Well, I'm sorry, I'm just bouncing off.
No, I'm saying if we're talking about.
Isn't this fun?
It is fun, and I wish I had more than 20 minutes.
I was simply saying, if we're getting back to your foreseeable argument.
Yes.
Is that inextricably tied with the fact that it happened to fewer than all of the lots, even though your own declaration says that it can apply to fewer than all of the lots?
Yeah, but still it has to be a change, whether as to all or fewer than all. It has to be a change that is reasonable and foreseeable. And, my starting point is Callaway decides this case.
Mr. Workin,
Yes.
what is reasonable, what would be reasonable and foreseeable then? What needed to be in here for Thompson Trust to do what it needs to do?
I don't think there's any way that it can be done, because there's no clue in these restrictions that there might be a change to allow development of one of these lots, or more than one, as commercial property or as industrial or as anything else. There's just no hint of it, no clue. So it's not foreseeable. There's...
My question was, venture into the hypothetical with me here, what needs to be in there that would have justified this?
It would have to be some sort of more explicit provision that would allow for an exception to or an abrogation of the residential-only restriction.
But isn't that
We're not
exactly
here
what Mr. Workin, isn't that what Callaway says exactly is not needed? I mean, Callaway says that you don't need to have any specific explicit direction about what it is because that's not likely to occur.
But you have to have, in Callaway, as in that passage, the court is talking about some amendment that fills in a gap or that refines an existing restriction, and I forgot what the third one is, but not a wholesale change, a night and day change from residential to commercial. That doesn't fill in a gap. That doesn't refine the residential only restriction. So there's, I'm trying to think of the case, it's the one that talked about the sign-free community. And the folks had a vested right to live in a sign-free community. The name of it is escaping me, but we've all cited it and discussed it in the briefs. But the out in that case that predicted that it might be changed to allow signs or to prohibit signs, whichever way it was running, was that it was depending upon changes in the law. So if there's some change in the law came along that forbade a prohibition on for sale signs, even though the covenant said no for sale signs in our neighborhood, well, that was contemplated because the restriction said, subject to changes in the law. But we're not here to draft a perfect set of restrictions. We have to live with and interpret and apply the ones that we have. And what we have here is very simple and straightforward, residential only. And that's what everybody reasonably expected who lived within that neighborhood, and especially those living right next door.
Just out of curiosity, is the policy for more freedom to use your land as you wish, or is the policy against? The policy is, if you look at Powell versus Washburn, it rejected the highest and best use or freedom of use argument and said that modern courts recognize the importance of restrictions and give those restrictions priority over someone's claimed freedom to use their property as they wish. And I'm not disputing that, but what I am saying here is that you have a situation where the contracting parties have agreed to eliminate a piece of that, and you're saying that is not possible.
It has to be.
So those cases you're talking about acknowledge the virtue of being able to make land subject to restrictions, reasonable restrictions by agreement, right?
Correct.
Okay, but what you're arguing for is you can no longer agree. You can't. So that's the documents in Tally Ho say we can change this. And then a group of the owners say, we are changing this. And your argument is, you cannot change this.
In a way that is not reasonable and foreseeable.
Okay. I understand.
Okay. That's my hill to die on.
Very well.
And as I've said, it's and Judge Morse disagrees with me, perhaps it's just not foreseeable.
Who knows what I really think? So
I never do,
yeah.
But that's the fun of it. So it just could not be contemplated. It was not within the reasonable expectations of these homeowners that they would have a commercial development in their neighborhood. So
I'll tell you what I think. I think that because of what we talked about earlier, because of the explicit provisions in there, it says we can just get rid of all these and we can end up with all commercial. It's foreseeable that this could go away and quit being a residential only neighborhood. I'm more kind of persuaded by the idea that it's not foreseeable that you could single us out. But then there's that language in the CC&Rs that says, that Judge Bailey read earlier, that said, yeah, but the CC&Rs say we can make these amendments to some or all of the properties. So give me your best response to that, because I view foreseeability as two issues. One is foreseeability residential commercial, and then foreseeability as just my neighbor. You know,
Okay.
you hate the idea of three neighbors who live in a corner get crossways with the other 79 property owners, and they say, all right, we're going to approve a chicken rendering plant right next door to you, and we'll get rid of you guys and get you to move out. So how do you respond to that language in the CC&Rs that says some or all?
Well, I still think that what might be done to some has to be reasonable and foreseeable. And if it's going to be ununiform, then it has to pass a different test, and that is it has to have the approval of those who are being,
Affected,
well, everybody's affected, and I'm going to come to that
but
point.
more affected than
But
the
it has to have the consent of those who are either suffering a new restriction or being relieved of a
You would agree
previous.
that goes beyond what Coway, I mean, Coway took beyond, explicitly said, we're not deciding this issue, didn't they?
No, they didn't. Not explicitly. And in fact, if you look at Coway in paragraph 19, our holding today requires that the original declaration give fair notice of any enacted amendment. So whether it's an amendment that adds a restriction or removes property from a restriction or removes a restriction from a property, it's at the bottom of the last sentence of 19, yes. Whichever way the amendment cuts, the reasoning of Coway applies with equal force. And that is because that all the amendments depend upon the reasonable expectations of the parties, and to add an unknown term is beyond the range of reasonable expectations, and it also alters the nature of the original obligation.
Mr. Workin,
Yes.
this is the corner of Rural and Warner.
It is, yes.
Okay. What's the zoning there on these parcels?
I think it's residential right now, but there is an application pending to change that zoning, this is my understanding, and also an application pending for some specific use. But I think that has been suspended in the city for some time during this litigation.
Are Rural Road and Warner Road commercial areas?
It's a mix, Your Honor. If you look, I think I'm going to say kitty corner across the street, there's residential over there. In fact, there's an aerial photograph here in the record. There's one corner that's something of a shopping center, a strip mall or something. So it's a mix. But the fact that things have changed and commercial has come into the area since 1965 when these restrictions were recorded is of no matter. Because under Continental and then later under Camelback del Este, the public policy of the state is to protect the property rights of the owners. Even though the nature of the community has changed or the nature of the neighborhood has changed, Roosevelt and 7th Street was, on the verge or edge of town, back when Continental was decided in the 30s. Somebody wanted to put a gas station on the corner. That was in conflict with the deed restrictions. The court said, no, can't do it, even though since the time of the recording of it, the area around there has changed. The city has grown. And you can't do it to justify commercial purposes just because somebody thinks that commercial is the highest and best use. I'm getting down to the 2-minute warning, and I'll have
You
to
want to
go.
reserve your time. So
I'll
stop the clock.
Thank you.
2:05.
Very good.
Yeah.
Good morning. May it please the court. My name is Cameron Artigue for Thompson Thrift Development. The court's first question hit the nail on the head. In 2020, a majority, instead of allowing commercial on the corner of Warner and Rural, that same majority could have said, you know what? The whole thing's repealed. The CC&Rs are gone. No more restrictions of any type. And if a bare majority can do that, There's no reason that a supermajority can't make a smaller, more incremental change on the corner. Now, let me take a step back, because what happened here was ordained, it's in furtherance of the statute that was enacted in 2016, where the legislature said, we want to open up older subdivisions. We want to facilitate the updating of old deed restrictions that no longer match the urban patterns within our cities. There was never a house built here, and it's 2020, and a residential use doesn't make any sense here. And my client did exactly what the statute enables you to do, which is go around and see if people support it or not. To your point, Judge Morse, there was an old case called La Esperanza that required amendments to apply to all parcels. And the 2016 statute enacted 33440C2, which says an amendment may apply to less than all parcels, provided that all the parcels to which it applies, those owners sign. That's to prevent oppression. That's to prevent injustice and bad faith. That's to prevent what happened to Mr. Callaway, frankly, where his neighbors ganged up on him and said, we don't like your goats and your horses, so we're going to ban them. This is not an oppression case. This is not a prevention of oppression case. The Callaway principle is about protecting a property owner's right to use their property as they were permitted to use it at the time they bought it. That doesn't apply here. Callaway's a shield. Callaway's a defensive mechanism. That's what Callaway says. Chief Justice Brutinel says in paragraph 15, we're here to talk about protecting the rights of property owners to use their own property.
So you're saying that this is a one-way ratchet, right? Callaway it can back off, but it can't increase. Is that what you're saying?
I am. I think that is the best way to interpret Callaway, the fairest way to read Callaway.
But Callaway doesn't say that.
Callaway doesn't say that.
Well, in paragraph 1, Callaway says, we are looking at the issue of whether you can add restrictions to property.
Absolutely right.
Now, paragraph 19, which your colleague relies on, says any amendment, but the whole premise of the case is adding restrictions.
I agree 100%, Judge Morris. I agree 100%. And if you look back at Dreamland, which Callaway enthusiastically supports, Dreamland is shot through with...
How do you know enthusiastic? I don't know if it would...
I forget the Supreme Court's language, but they said something like, we're very impressed with it, or something like that. So it was a good opinion.
Okay.
But Dreamland says, it all talks about imposing new restrictions. And if you look back even before Dreamland, to what Dreamland called the Lakeland line of cases, they go back to the 1980s. Every one is the defensive doctrine I talked about. It's all about protecting the landowner against a gang up, or about in my neighborhood. If my neighbors can't enact a no work from home deed restriction because they don't like me, that I would have a Callaway argument from that. But if my neighborhood says,
if your neighborhood decides to put a chicken rendering plant next to you, what's your remedy?
Oh, well, if the CC&Rs say no, residential use only, I've got a remedy, clearly.
That's what yours said, is residential use only.
No. Well, but
let's say the neighbors think you're the odd one out. We got to get rid of this guy. He has too loud of parties.
No, if the Callaway is designed to prevent oppression. So if I have a chicken ranch, like Mr. Callaway had horses, and if my neighbors don't like that and amend the deed restrictions, that's a Callaway argument. I agree, that's triggered.
No, what I'm saying is if they turn it free-for-all or invite a brothel in or something that you really don't want to live next to as an effort to get rid of you, you're just without luck because that's taking away restrictions.
No, but it's not. I never had those restrictions. My contract rights say that my CC&Rs can be amended in whole or in part. and roll over every 10 years. And Callaway doesn't give me a sword.
Does it matter that, because you complimented my question earlier, but does it matter that this wasn't the normal 10-year renewal, that you went off?
Nope, doesn't matter. That subsection of the statute addressed another case called Schulten versus Blackhawk
No, I'm
Partners,
saying
but-
in your CC&Rs it says, by the way, every 10 years you're on notice, so we're talking about notice here, sufficient notice under Callaway. It says every 10 years we could vote to continue these or discontinue these. And I think that's persuasive in that, saying that you're on notice that this residential might not continue forever. But you guys went off the 10-year window. You did this in the middle of it.
I think the moral and legal force of the 10-year provision
Don't expect the law to be moral. So
was-
let's talk about the legal.
But it was extinguished in 2016 when the legislation said any amendments can be made at any time and they're effective upon recording. So that's a legislative declaration that those 10-year things don't really matter anymore. So again, we effectuated exactly.
Let's focus just on foreseeability and
Okay.
say the statute doesn't apply. Is it foreseeable that there could have been an amendment off that 10-year rotation
Yes.
that would apply? How?
Yeah, because the statute says.
What is the CC&R?
Well, actually, no. The 1990s case. First of all, these deed restrictions date from 1965. So I don't know what time we're supposed to be looking at. 1965, or when each owner bought, or
Let's assume that
1992.
I'm focused solely upon the CC&Rs. What
Okay.
do they say? Does it allow this non-10-year amendment to take place at year 5?
What the old Schulten case said is that amendments can be adopted during the 10-year interval, but they only become effective on the 10-year anniversary date. That case was overruled by HB 2382 in 2016, where it said amendments take effect upon recording.
Okay. I'm obviously not asking the question well.
Okay, okay.
Did the CC&Rs allow off of 10-year amendments?
No, they did not. As written in 1965, they did not, Your Honor.
Okay.
Can we resolve this case without deciding whether Callaway applies to lifting of restrictions?
Yeah, I think you can. I think it is permissible. Yeah, I think that this clearly Callaway envisions a determination of law, because that's what the Supreme Court did in the second half of its opinion, a determination of law that the reason and foreseeability standard has been met. And I think the court can make that determination as a matter of law. I shudder to think what it would mean for that to become a fact issue, because if we said we have to go to trial on every deed restriction and every subdivision every time somebody wants to, because people will not, you can always proffer testimony that something wasn't foreseeable. So we can't have a regime where there's a trial necessitated over the enforceability of every deed restriction.
Wouldn't that be wonderful for your retirement plan?
Well, yes. Yes, it would be wonderful for my retirement plan.
Inappropriate jokes.
No, thank you. But no, it's not an administrable regime. I also think, to answer your question, Judge Bailey, I think that creates tension with the statute. I mean, that's mentioned in the brief.
To say that Callaway applies to lifting restrictions?
Yeah, I mean, when the legislature says we want to facilitate amendments and updates to deed restrictions, the common law is supposed to yield to that. And I think it's a little bit irregular for the judiciary, with all respect, to say not so fast. The common law stands in the way of that statute. It's supposed to be the other way around. And yeah, this court's bound by Callaway, but the best harmony, the harmonization, I think, if you want to go that route, is to say Callaway, it only applies to imposition of new and additional restrictions.
Well, I'm
That's
saying,
it
what if we
says.
don't, not saying that at all, not even couching whether Callaway is narrow only to new restrictions or is broader in that it can also apply when you are lifting a restriction on property, which is what I mean, for lack of a better term, lifting the restriction that this be residential.
No, I think I think I'm answering your question. You can determine this case by saying Callaway's complied with. I mean, you can also determine this case by saying Callaway doesn't apply to begin with, which is what Judge Blaney concluded in the Superior Court. But, this is, to say that the northwest corner, it's somehow shocking and unforeseeable that an urban area of Tempe would have a restaurant
Are they
on
the only
corner.
3 lots that aren't built on?
Yeah, these are 3 lots. There's 2 whole lots, and then the southern half
But is
of...
everything else developed residential? Are there any other open lots?
There are no other commercial developments. Because this is the port, and there's nothing else non-residential.
But is in this tally-ho,
Yes.
these 2.5 lots have nothing on them?
Correct.
Does every other lot in tally-ho have a house on it, or are there other empty lots?
I can't speak to whether, Judge, if there's like some lot that, with the house burned down and hasn't been rebuilt,
Right.
That may
But it's
exist.
otherwise developed, and
But
I
no,
assume these 2.5 have been sitting there
Yes.
since 1965?
Yes, these
Undeveloped?
lots have been vacant since 1965.
Okay.
So, it is, there is another route that, we could have gone in and argued changed circumstances and said, hey, and that's another whole doctrine where we could go in and say, hey, court, this is no longer an alfalfa field like it was in 1965. This is now an urbanized part of Tempe. These CC&Rs no longer make sense. Get out your equitable pencil and relieve us of them. We didn't need to do that because we have the statute and we have the majority. So you go around and we have the deed restrictions that say they can be amended in whole or in part. We got the supermajority. We did what the statute allows us to do, and we would like to proceed. And with that, unless there are questions, I will sit down.
No questions. Thank you, counsel.
2-minute drill.
Go.
Okay. Calais recognized that this statute, actually its identical sister statute in the community association statutes, doesn't displace the common law. So it doesn't displace common law rights, and those include the rights to foreseeability, reasonableness, uniform application of restrictions.
But that analysis was on 1817, was it not?
But the
They didn't talk about 440.
No, they didn't, because Calais was treated as a community association. This Tally-Ho subdivision is not, but the wording of 33440C and 1817A are identical. So if the boys upstairs and girls are going to say, this doesn't displace the common law, it got to apply with equal force to 440C. And I would call to mind Judge Bailey's memorandum decision in McLeod last year, where she said even if an amendment adopted in compliance with 33440C, even if it is adopted in compliance with the statute, it's invalid without the consent of all owners if it's not reasonable and foreseeable. And so we come right back. The statute, by the way, Calais, of course, was decided after the statute was amended in 2016. Quickly, Calais is not a shield. It's not about just defense. It's about protecting property rights. And that's what I stood up here to say at the beginning. And I think my opponent reads too much into the statute. It doesn't overrule Schulten. There's no indication of that. One cannot reach that conclusion. And so at least the outcome of this case has to be that this amendment, if it is valid, it's not valid and effective today. It won't be until the expiration of the current duration period.
And when is that? You don't know? I'm not trying to trip you up.
No, you're not. You're just straining my memory.
Okay.
One can compute it looking at the Declaration of Restrictions.
Figure it out. Yes. All right, counsel, both of you, thank you very much for your arguments, your briefs, and your presentation today. We appreciate it. We will take this matter under advisement, issue a written decision in due course. We are now adjourned. I don't know why I emphasized adjourned.